Ini duduk dalam bilik lah. My wife ada kelas dia pula kat depan.
Tak boleh sebelah-sebelah saya, nanti confuse.
Macam mana Jamie?
Tak boleh sebelah-sebelah, nanti confuse. Kita dengar siapa punya lecture.
Jenuh nak lawan suara. So you all punya assignment semua dah siap dah?
Tak juga.
Ada paper semua dah? Okay.
Tak tahulah, banyak lah, depends lah. Kalau saya ambil 5 subjek, banyak lah.
Assignment you ada yang pending lagi?
Oh tak ada, untuk subjek talk ni tak ada, tapi subjek lain ada.
Oh masih pending lagi lah. Macam saya dah memang plan untuk nak bagi kat you all semua. So you don't like kata stress bila towards the end. Okay, you rasa lega. Tak tahu lah, paper apa yang you all masih ada pending nak submission ni?
Kalau macam saya, last day misalnya berkata besok juris last day, criminal esok last day, land law hari ni last day.
So ramai yang tak hadir lah hari ni.
Tak tahu lah, kita tengok keadaan macam ni je. Sampai pukul dekat pukul 3 pagi. Aduh.
You all ada discuss untuk kelas tambahan?
Belum, nampak tu senyap je. Jadinya nanti masa dah last kelas ni kita orang terus decide lah, senang.
Boleh. Tak kisahlah, at least ada 3 orang pun dah kira berbaloi dah. You know, you don't have it does not need to be like a full 3 hours punya session. Just wrap up je kan, nak cari apa. There might be one topic yang memang I tak sempat rasanya hari ni. One topic, the last topic tu, remedy. Remedy tu I think is clear cut. Cumanya kalaulah remedy tu tak boleh cover, I akan buat revision tu, I akan buat remedy tu sekejap and then kita sambung lah. That might be more than 1 hour. Boleh ke?
Boleh. Cun.
Boleh lah, insyaAllah. Right. Nak tunggu dekat lagi ke macam mana? I was anticipating kata kita ada 2, 4, 5.
5 je?
Azil, Azizul, Jamie, Nita dengan Wan. Dah orang nak masuk. Yanti.
Assalamualaikum, sir.
Waalaikumsalam warahmatullahi. Before kita start, do you have any questions on the previous punya, apa orang kata, previous punya kelas? Anyone? Do you have any questions?
Tak ada, sebab rasanya yang last class tu breach of statutory duty tu macam is a very straightforward, cuma dia cover macam-macam contoh macam tu kan.
Yeah, true. Quite straightforward, tapi dia technical sikit lah. Bila straightforward tu ada technical sikit.
Sebab dia kita boleh guna macam occupiers liability, kita boleh guna macam vicarious liability untuk benda tu untuk cover ataupun negligence kan. Jadi dia macam
betul. Agree, Jamie, because dia punya konsep dia cuma macam lapis-lapis lah. Dia actually not by, it does not stand on its own. Cuma dia lapisan-lapisan ni kan. So you boleh ambil lapis tu dengan letak dengan negligent, dengan as what Jamie kata, dengan vicarious liability, dengan strict liability, semua boleh campur. Because
Kalau kita cakap statutory duty bermakna cuma untuk official duty lah kan, macam government lah kan, ataupun government link related punya thing lah.
Tak juga. Anyone that is that is forced to follow a certain law.
Oh ya.
So katalah a duty that is imposed by law towards you, so you don't have to be a government servant. You can be a government servant, tapi kalau you are not a government servant, you are compelled by a specific law. So if you fail to do that, I suffer. So I have the right to sue you for my damages because you default in following the law. Ya, you
Jadi
tu
bermakna
maksudnya
dia
macam mana?
boleh kepada syarikat ataupun individu pun boleh lah kalau gitu kan.
Boleh. Because syarikat dengan individu there is no difference lah. Cuma ada one kita panggil legal person, the other is actual human lah. Kan? Dekat company, you belajar company law kan?
Belum belajar lagi.
Company law, company is is a person lah, is a legal person that is created under law. Dia stand on its own. Meaning dia boleh, dia macam manusia lah, tapi dia artificial punya recognition. So,
Dia dalam
jadi, ya.
oh, sorry.
Actually,
Saya cakap tadi company itu makna antara subjek dalam law of association ke sir? Yang ada partnership act semua tu.
yeah. You will learn that. SO1, SO2 kan? SO1, it's all about company lah. So kita ni yang dah senior ni dah matured, then it's quite easy lah for us to understand company law. So kita are aware of companies kan. But student lah, dia orang kesian. Dia orang tak tahu kan how companies, tapi dia orang belajar macam in the dark lah. Tak nampak kan.
Satu soalan boleh tak?
Boleh lah, boleh. Apa pun tak apa, tak kisah.
Berkaitan dengan breach of statutory duty ni, yang elemen B, kita ada A, B, C kan, itu analogi untuk nak faham kan. Yang B pasal law ni, macam mana normal person yang boleh tahu law tu wujud? Law company ni kan.
Dia sebenarnya under imposition of the law ni kita kadang-kadang kita aware, kadang-kadang kita tak aware. So the law, dia punya rule is ignorance of law is no defense. So you tak boleh kata, oops, saya tak tahulah undang-undang tu ada. So court akan kata, too bad lah, you tak tahu kan, tapi undang-undang tu ada. So kita ni sebagai seorang yang menjalankan sesuatu, kita kena tahu apa undang-undang yang regulate perbuatan kita tadi. So if you were to do something, you must be able to do your due diligence lah. Maksudnya you kena check. Kalau I nak pergi buat nak korek tanah, what is my right, what is the duty, if I'm doing it under certain situation, apa dia punya regulation yang ada. Kalau I sebagai satu syarikat yang menjalankan satu perusahaan kilang, say for example kan, you are doing a manufacturing punya ni, so you have to be aware what would be the laws regarding kilang-kilang when yalah. Macam SOCSO, kalau you ada staff lah kan, ada EPF, SOCSO, all those are you ada Pekeso, apa yang safety ni apa dia? Cik lupa pula. Lupa lah. Apa dia?
ICE tu apa? Yang untuk itu insurance.
Tak kira lah. Dia memang banyak lah. If you were to conduct a business, dia ada banyak regulation. So jadinya kita tak boleh nak kata saya tak tahu. Okay? ignorance of law is no defense. That is basis yang semua orang kena tahulah. Undang-undang dia tak boleh guna alasan kata dia tak tahu.
Okay.
Okay, good. Boleh lagi soalan? Anyone? Right, kalau tak ada, kita ada 14 kita kat sini. So let us continue. Auzubillahi minasyaitonirrajim. Bismillahirrahmanirrahim. Bismillahirrahmanirrahim. Okay, so untuk kita nak dive into this vicarious liability punya topik, right? Vicarious liability as mentioned hari tu, I don't know, kejap, my wife tegur, kata, you are using bahasa more than you are supposed to use English. Tapi, I don't know, you all macam mana?
Saya okey je, sir. I mean,
Okay je, sir. I mean,
okay,
pemahaman semua
kita
sama kot.
takut nanti complaints lah, kata he is using bahasa. I don't want that to be an issue lah, tapi you know, I don't know. Okay, tak apa, insyaAllah kita boleh pakai ni lah, dua-dua lah, campur senang sikit. When it comes to vicarious liability, as already discussed last week, it is about the liability, which is vicarious, meaning an extension of the liability yang di mana seseorang tu kalau he is to do something of a thought, that particular thought liability would be extended to the employer, or maybe to the extent of the nanti kita tengok whether agent, whether independent contractor. But initially vicarious liability yang memang for sure it is about the relationship between employee employer. Once you have that relationship, activity yang mendatangkan liability ataupun mendatangkan damages to other people, then the employee is responsible, and you as the person who suffered the outcome of the employee punya act, tortious act, so you can sue the employee and also his or her employer in order for you to recover the amount that you suffered. Because the logic is, if you were not to allow to sue employer and only restricted to only employee alone, then the chances of you recover your damages is not very likely, because the amount might go to hundreds of thousands of ringgit. So in order for the employee to come up with a big amount of money to satisfy your claim, he might end up, bayar mungkin 10 tahun, or maybe 20 tahun untuk dia nak bayar. So he can only can afford paying 500 per month. You want that possible. So you can take the employer also to court and say that, look, he is your employee, you have gained all the advantages of employing him. So if he were to commit any tortious act that I now suffer, you are now responsible for his activities, or his action. So in order to establish vicarious liability, there are 3 elements that you have to satisfy. Meaning, kalau you tengok kat sini, dia ada plus lah, kita tambah. There is no plus. Mana plus ni? Ni plus. Okay. This one ada plus, and then insert the one. Where was it? Okay. Right. So the formula would be wrong. Talking about negligence, then you have to prove negligence. Remember, thoughts one, and then if the thing is about trespass, then you have to establish trespass. Kalau Ryland, and then you have to prove Ryland. So once the thought is being established, that satisfies the first requirement. The next requirement would be special relationship. The special relationship is the relationship between employee and employer. You must be able to establish that relationship, right? So you, meaning the plaintiff, must be able to do that, to establish that the employee is indeed the staff or the worker of the employer. So in order to do that, we have the differentiation between
Saya ya seorang saja yang putus-putus ke memang
contract
semua putus-putus? Sorry
of
sir.
Saya pun sama. Dia macam
Sebab
putus-putus.
macam putus-putus sir. You
is
cakap
forcing. Suara I putus-putus.
Yes. Breaking.
satu perkataan lepas tu nanti tak
Seriously?
dengar
Oh,
satu lagi.
Saya ingat saya seorang ni.
Oh, tidak.
Sama iPhone.
Allah Akbar. Now clear sikit.
Yes. Sekarang clear.
Oh, okay. Sebab pintu tadi tutup, dia wifi dah ada kat luar.
Okey.
Okay, saya ulang balik. Dekat mana yang putus-putus tu? Semua?
Tak apalah saya start aja daripada Wrongful Act tu.
No.
Sir,
suara tak ada.
terus hilang. Sir, sorry
No
sir.
point
Memang
for
tak dengar.
Sir. Sorry sir,
Macam ni.
tak dengar saya cakap apa.
Wait. I try pakai. Ya. Oh, ya. Allahu Akbar. Apa hal lah?
Mesti sebab saya selalunya buat kat luar, hari ni kat bilik dia jadi putus-putus.
Mungkin file buka banyak ke kejap. Kadang-kadang dia take up a lot jadi
Sir, planning nak ke mana tu?
macam mana sekarang?
Okay, better.
Tapi Garmin tu dia tak updated map. Ya. Ni pakai ni boleh dengar?
Boleh sir. Dia dengar tu boleh sir,
Yang ni
tapi
clear?
nanti ada ketikanya tu saya cakap dia putus. So kita tak tahu the full sentence saja. Tapi sekarang okey kot sekarang. Cuba saya try continue, maybe now is okay. Kalau putus-putus.
Dia kalau ada juga saya kena try to minimize everything. Kalau tak ada putus-putus, just message masuk dalam chat tu. Can you say putus?
Okay, yes. Okay, continue.
Hello. Okay, alright. Alright, balik kepada tadi vicarious liability is a tools yang you as a lawyer to your client yang akan pakai. Kenapa bila kita nak pakai vicarious liability as a tools, apa tools ni? So this tool is actually to be able for you to sue the employer of the person that yang buat tortious act tu. So kalau dia buat something, say for example negligent, and then say for example you nampak kereta-kereta yang kat luar kan, kereta-kereta yang company, yang obviously bawa kadang-kadang laju, and then kita tengok lori, under company, and bila dia bawa negligent, mengakibatkan accident. So those person that is injured or suffered damages, they can obviously sue the person who created that thought. Meaning kalau dia negligent, then you suffered injury, then you can sue that person lah, that driver. But you obviously it is difficult for you to get the compensation lah. Kalau lah tak ada insurance compensation scheme. Say you wanted more than the insurance punya coverage. Because insurance ni dia cover a certain amount. So what you need to do is to extend the liability of that person, the driver tadi. So you nak saman dia punya employer. So katalah yang negligent ni driver tangki minyak, yang menyebabkan explosion. So obviously you want to sue that person, tak mungkin dia nak bayar because mungkin dia dah mati dah, and mungkin dia orang yang miskin, berapa gaji dia sangat. Mungkin driver tangki, berapa gaji orang bawa tangki minyak sebulan? Adalah dalam 15,000, right? I think 15,000 lah. It is not enough to compensate balik, especially kalau dia tak ambil insurance. So obviously you want to sue the employer, which is katakan Shell ataupun Petronas punya company, because Shell, Petronas, they are obviously dia orang kaya kan, so obviously dia orang tak nak tarnish their name. If they lose the case in court, obviously they automatically akan bayar semua, dia tak akan delay. Kalau employee tadi mungkin dia akan delay another 5 years or 10 years maybe, ataupun tak boleh bayar langsung. So your task as a lawyer later on is to protect your interest of your client, and to be able to know how to make the employer responsible for the employee tortious activities. So that is what we call vicarious liability. So this vicarious liability is just a tool that you are going to use. However, in order for you to successfully utilize vicarious liability, there will be a formula ataupun elements that needs to be fulfilled. So the first one is wrongful tortious act has to be established. So if there is no wrongful act that you can prove in court, obviously you don't have the right to sue the employer, right? Because the employee would run away lah, obviously, because you have failed to prove that he is negligent ataupun he is a person who acted in a way that is wrongful, in the rest of the things yang kita dah belajar kan. So any tortious act must be established first. Okay, so that is the first one. That is the first requirement. Then you have to add that the relationship between the employer and employer must be established. Kalau you tak boleh establish, then you fail lah to sue the employer. You can only sue the employee. You need to establish the special relationship because you want that relationship to be established between employee and employer. So katalah the employee, you say that so-called person yang buat thought tadi is a person, katalah A ni. Kalau A ni dia you try to establish the relationship between A and the employer, it turns out that A is actually an independent contractor. Okay, kalau independent contractor, you tak boleh saman lah, because dia tak ada nexus ataupun tak ada linkage in terms of special relationship. So ingat tak kalau kita dekat Talks 1 kita belajar special relationship in terms of love and affection bila psychiatric injury kan. So if you are the one that is not involved in the accident, so you want to sue that person of negligence because you now suffer mental illnesses because you saw somebody of your loved ones involved in the accident. So you must prove that special relationship. So sama juga dengan sini. In order for you to claim that the employer is to be responsible for the employee punya activity, then you have to establish the special relationship. This can be defined, kalau lah kata dia by virtue of contract, that relationship can be determined by virtue of contract. So one is contract of service, the other one is contract for service. Kalau for service ni selalunya kita ambil orang, kita minta dia buat sesuatu. So they are considered as contractor. So if they are independent contractor, the likeliness of you to be responsible for the act of independent contractor is not likely. Tapi tak semestinya kata you boleh lari. There are situation yang kita akan go through nanti that the employer ataupun the one that engaging the contractor is to be responsible. However, yang kita nak tengok is that special relationship in terms of contract of service. Contract of service macam kita dengan kita punya majikan lah. All of us bekerja, hopefully. So kalau kita bekerja, obviously we are under a special relationship with our employer. Now, untuk the court to establish how to differentiate between contractor dengan employer punya relationship, there would be a test that has to be done in order for the court to identify clearly who is going to be responsible in terms of whether there is a special relationship or not. One is being used, the test, the initial test that has been used is the control test. Control test is to determine whether the employer has the ability to control the employee. Dia ada sub test lah, ada 4 sub test dekat control test. And then we have the integral test, meaning this is the later test. Dulu dia orang pakai control test, tapi this control test ada sikit problem bila kita apply that test, because in certain situation of an employee, people like macam myself, whether I am an employee or not. Susah sikit kalau ini kita dah nampak terms and condition of employment. Tapi kalau kita ambil doctors, when you go to the hospital, doctors bukan, they are not engaged by the hospital by virtue of employment, tetapi by virtue of service. Okay, so they by nature is they are not, they orang tak dapat gaji daripada hospital. Dia orang cuma dapat remuneration in terms of macam contract lah, right? So macam specialist, so they are independent. They give their services to all hospitals. So they are not engaged by a specific hospital under employment. They are on call ataupun they are independent, that they can go any hospital, right? Because of the inability for the hospital to maintain the salary of that particular doctor. Kalau specialist ni, macam as I mentioned last week, my cousin, dia gaji dia 112,000 sebulan because of neurosurgeon, a specialist. So hospitals, they can't afford to have this type of doctors to pay. Kalau lah say for example that month tak ada neurosurgeon punya neurosurgery, So the hospital is going to lose out in terms of nak kena bayar gaji kan. So what is the position? Kalau lah kata doktor tu negligent, right? Tapi dia independent doctor. And then dia buat pula dekat hospital yang engage dia untuk nak buat operation tadi. So is the hospital also responsible? Can the hospital be made vicariously liable? That is the question yang kita kena tengok lah. So that is the integral part. Meaning the question by the court is tengok dia punya activity. What is the activity of that particular person? If the activity of that particular person is very important to the institution that he or she is working, then obviously that person is no longer considered as independent but as an employee. Ya, sebab control test ni tak boleh nak determine when it comes to that. Nanti kita go into detail, just giving you a bird's eye view. And then we have the mixed test. Mixed test ni is a combination of control test dengan integral test, because the court discovered that they cannot go to rely on only control test ataupun only on integral test. So what they did is was to mix them up, to control test and integral test together. So we call it mixed test. So nowadays it is more towards mixed test. Yeah. But if it can be resolved by using control test, then obviously the court will utilize control test. If it's not, when it comes to complicated cases, then they will try to utilize both. So that is the second requirement. You must be able to prove as a lawyer to your client who is suffering damages. You must show to the court that the employee and employer relationship does exist, and you can do that by virtue of the test. So obviously the test is going to be verified by the court. So you have to prove yourself in terms of the test itself. So when you claim for your client, obviously this so-called indication that the special relationship is established by virtue of either the one of the tests. Yeah, so that is your duty. Second duty. The third duty as a lawyer for your client, in order for you to make sure that the employer is responsible, employer of that the defendant. So you must show that the thought that the defendant did was occurring within the course of employment. So mesti berlaku dalam masa dia menjalankan tugas sebagai seorang employee. It must be done within the course of his employment. So that course of employment is something of a subjective nature. So we need to identify this by virtue of all the cases. Macam mana the court identify the course of employment. Okay. So the cost of employment is very important for us to determine. Special relationship dengan Tortures Act ni dah, Wrongful Tortures Act by itself kita dah tahu. Special relationship is something new, right? But the one that is a bit complicated is going to be here. Dia orang boleh masuk tak? Okay. So it's going to be here where it is all about the cost of employment. So what you have to understand right now before we jump in is that it brings benefit. Anything that brings benefit to the employer while the employee is doing the activity in the course of employment is going to be in a position of accuracy liable. So kalau you claim 100,000, so chances of you getting for the amount compensation from the employer is very likely lah. Okay, question.
Sir, kalau kat
Yes.
buku Nur Cahaya tu, control test tu namanya sama lah kan, integral test, is it the organisation test, and the mixed test is a multiple test?
Sama je nama dia lain. Organizational test ni, whether you are core, whether you are the integral part of the organisation. So contohnya kalau kita nak ambil saya dengan ITM, right? Compare to makcik yang cleaner, if makcik cleaner di UiTM were to be negligent, dia dia mop lantai, ada banyak soap yang dia pakai, student jalan jatuh, patah kata patah kaki. So the student can claim from whom? Is it to the makcik? Obviously the makcik is the one that caused the negligent, right? Negligent act. So can the student sue ITM in order for that student to compensate the damages? Or can ITM say, excuse me, that makcik is not my employer. Not my employee. It's not my staff. Compare that with me, Haris, that is working under your ITM under contract of service. So therefore, Haris has terms and condition employment and things like that. So obviously you can utilize the relationship of me and ITM. Kalau tak ada lah, say for example the contract says contract of service, katalah contract tadi, contract of employment, tulis kat atas besar contract of employment of Muhammad Haris to the part-time lecturer as of UiTM. If I were to do any negligent act, say for example I tampar student, right? Whether the student can use my act, which is trespass, to also make UiTM responsible. So ITM can say, excuse me, he is a contractor. The contract itself, you can see this is one copy of the contract, says that clearly he is a contract for service. So if you bring this argument to the court, you have to prove that actually by using integral test ataupun organizational test, Haris, is the integral part of the organization. So irrespective whether the contract, physical contract, is stating contract for service, he is actually doing something that is core to the business of UiTM, which is teaching. Therefore, he is actually having the relationship of employee-employer relationship. So tak payah lari lah. ITM cannot run away. But when it comes to makcik tadi, ITM can come up with a document saying that this makcik was not employed by them and things like that. So makcik is not the integral part of the ITM. Yes, makcik can contribute to the cleanliness of UiTM, but not to the core business of UiTM, which is teaching, which is lecturing. So ada beza between me and her. Yes.
So nak tanya sikit?
Boleh.
So what about for employment for services?
Employment for services, dia
Does
by
that
default
the same thing apply?
This one, the contract for service, right? For example, ITM boleh lari lah if ITM can show that they engage in a contractual relationship with the employer of that makcik. So if ITM can show that they are not, the makcik is not their employee by virtue of their contract between the makcik punya employer, selalunya kita ada one syarikat cleaning, so ITM can wave their hands and say that I'm not going to be responsible. You want to sue, you sue that the employer of that makcik, which is the cleaning service punya company.
What if the approach of UiTM engaging into employment for services for core macam core apa tu? Macam teaching. Okay, you appoint an external party under employment for services to provide services in terms of teaching. Macam mana tu?
So just now I already explained, katalah myself is an part-time lecturer, right? So if part-time lecturer, then it is under contract for service. Betul tak?
Betul.
Because you don't want to pay PF, SOKSO, segala datuk nenek kan? Because whenever an employer mesti ada legal liability kan, duty. So ATM nak lari, dia kata okay, we engage you on part-time basis. So engaging in part-time basis, katalah I as a part-time lecturer were to do something that is tortious in nature, apa-apa talk yang I buat. So the issue might come up. Kalau you pakai control test, obviously ITM says that he is not our employee. So memang fail lah control test. Tapi kalau you pakai intergroup test, meaning look at Haris activity. What is his activity? Teaching kan? What is the core business of your ITM? Is it teaching? Yeah. If the answer is yes, then obviously I would be an employee of UITM. So there is a, sorry, it's not employee, but there is a special relationship.
I see. Thank you, sir.
Welcome. So kita nak clarify sebelum kita terjun masuk ke dalam benda ni. Any questions so far? So ada 3 elemen, so tiga-tiga kena establish. Kalau you nak saman the person we are looking at the relationship between the defendant and somebody higher. You know, that higher person is the one yang kita nak attack. Because by attacking that person, obviously kita akan dapat banyak duit lah, ataupun cepat bayar. Questions so far? Kalau semua dah okay, you can tulis chat lah, senang sikit I boleh nampak. Okay tak?
Okay, boleh.
Alright. So we go into the document itself. Now looking at the vicarious liability, as I already mentioned, it is a relationship lah punya issue. Yeah, you need to establish that relationship. Kalau you are unable to prove the relationship of master and servant ataupun employer, you know, between principal and his agent, and then you are going to be in a difficult situation lah kalau you nak saman the the person that you wanted to sue. You can sue the defendant, obviously, yes, no problem. You can prove that that person has done something towards your client. Tetapi kalau nak claim towards the other person, the company, you know, which is deeper pocket, memang susah. Yeah, you have to establish that relationship. Now, kalau kita tengok reasons for vicarious liability according to Norcaya, dia letak in this manner lah. Whereby katalah the employee ini sebenarnya di-engage oleh employer, obviously to do work. So the employer obviously dapat benefit by the employees punya kerja, right? So tak aci lah, cuma kalau the positive sahaja yang employer nak nak dapat, ya. Bila buat benda yang negatif, when the employee is doing something that is negative in nature, then the employer say, oh, I don't want to be responsible. Then it's not fair. So the court is against that, in that nature. So you have to accept a person either good or bad. Okay, macam orang kata kahwin for the betterment of good and bad, you know. You tak boleh kata I nak ambil yang semua yang positif saja, yang negatif saya not going to be responsible, cannot. You have to terima seadanya. And then you want to be in the position that you want to claim from the master because that person is in a better financial position. Yeah. So in order for you to get your client to be compensated as soon as possible. Okay. Ini a case that elaborate that lah. So tak ada apa-apa ini. Let's look at the requirement, macam yang tadi saya dah katakan, the requirement of tort dengan special relationship dengan ni. Wrongful Tortures Act ini you have to do on your own lah, whatever it is, negligent ke, violent ke, vicarious statutory duty ke, negligent ke, nuisance ke, tak kisah. Special relationship, as I already mentioned, mesti ada establish that employee-employer relationship. Yeah. So whether a person is employee is based on that relationship lah. Okay. So normally kita determine by virtue of either it is contract of service ataupun contract for service. Dia ada of dengan for. Kalau for ni independent, of ni maksudnya employee-employer lah. For to establish contract of service, kita tengok control test. Control test ada 4 benda. The first one is to look at the power of selection. Maksudnya, you determine siapa yang engage this particular employee. In terms of interview, siapa buat? Siapa buat interview? Siapa yang select that particular employee? And if the employer is the one that conduct the interview, in order for the employee to be to be appointed ataupun selected, that is number one, the first requirement. Second, to determine the salary. Okay, salary pula. Kalau salary, siapa yang bayar? Is it the person yang buat selection tadi? So dia mesti ada 4. 4 ni maksudnya 1 plus 2 plus 3 plus 4. Mesti ada 4. So salary pula. Yang ketiga kita tengok in terms of method of work. Okay, macam mana cara-cara dia menjalankan tugas? Is it method of work is being determined by is being determined by the employer. Okay, if that person determines how you do your work or what types of work that you are supposed to do, then the method is being determined. And then the fourth one is the power in order for the person to terminate. Yeah. So power to terminate siapa? Is it because is it in the hands of the employer or that particular person? Okay. So these 4 elements must be satisfied. Boleh tak? Kalau kita dah ambil contoh, you all ambil saya lah, ambil saya. First, who select me to work? So ITM lah jawapannya, right? Because ada interview. Second, whether salary is being determined by whom? Siapa yang bayar gaji? ITM kan? ITM lah. So dah satisfy the second test. The third test, method of work. Okay, dia nak determine in terms of apa yang I mengajar, subjek apa, bila saya kena mengajar, pukul berapa, di kelas mana, specific class, which number of groups yang bawah saya. It is not being determined by myself. It is being determined by the management of the faculty, which is actually UiTM lah. So methods of work is being determined by UiTM. So satisfy lah. Tapi di sini ada isu sikit lah, di mana method tu, kalau kita perhaluskan, kita kata methods ITM do not go to the extent that Haris, you ajar topik ni hari ni, you kena cakap macam ni. That skill is being given towards me. So argument can go up to the court and saying that they decide which group for Haris to, or day that Haris to teach, but how Haris is to be teaching is his own. So that does not satisfy the method. Okay, ini the control of the method is the one that might cause a problem. That is orang kata yang kat bawah, statement kat bawah katakan control is no longer accurate in order for us to use control test. Okay, and the last one, the fourth one is terminate. Kalau nak kira terminate, semua boleh terminate kan? Termination in terms of termination of contract atau termination of employment. So, but more or less, I can say that ITM can terminate me lah in order for me to no longer work with ITM. So, ada 4 elements satisfied. Therefore, I am the employee of your ITM. If I am an employee, therefore there is a special relationship. If there is established special relationship, then satu dah ada, dua dah ada, and now have to determine whether apa yang saya buat tu must be within the cost of employment dalam waktu kerja, ya, ataupun dalam perjalanan pekerjaan yang diminta saya buat. Mungkin saya dihantar untuk ITM, from time to time akan appoint lecturers of law untuk ambil tindakan tata tertib terhadap staff ITM yang salah laku. So we are going to be appointed and go to that branch untuk dalam disciplinary punya ni lah, committee. So bila, if say for example, kalau I naik kereta ITM then accident, what is the liability of ITM? Even though perjalanan hari Ahad, not working day. So that is the question that we have to determine. So boleh nampak yang empat ni senang kalau kita pakai ni, empat ni. Anyone yang kita claim that the person is responsible for the Tortures Act, kita boleh determine sama ada dia employee or ada relationship, special relationship with somebody else. Clear, guys? Better to have. Maksudnya? Wan, macam mana Wan? Oh, right. Yeah, you kata tadi lah. Okay. So, then that is why I kata control test is not a good test. Tapi control test tu ada 4 elemen dia. So the issue here is about a professional person. Now, if that professional person is the thing that is in question, so the control test is not reliable, not accurate sangat lah. Sebab I can ITM can contest. Okay, Haris is not we are unable to control his method. So it is a fight between the plaintiff lawyer and the defendant lawyer to prove whether the person is actually in control of that particular defendant. Right. Question so far?
Tak ada, saya okey saya. Cuma tu yang empat-empat tu kena semua
so,
ada.
Kalau ada problem, mesti you cannot use that relationship. There is no relationship if one of them tak ada. So this control test is later developed into what we call organizational test ataupun integral test lah. So here we have a case of Stevenson, Jordan and Harrison, di mana Lord Denning kata it is is a problem for us to determine whether a person is having special relationship or not. So what we have to do is to identify whether that particular person activity is it the core of that particular relationship between the employer punya business, whether macam kita ambil contoh kat sini, dia kata captain of a ship, driver, professional driver ataupun driver, journalist, we can identify them as under contract of service. But ship pilot ni macam mana? Ship pilot, bila kapal dia nak sampai ke dermaga, captain of the ship cannot bring the kapal to the pier. A ship pilot is to be engaged. Dia malim, orang kata malim. Is it malim? Pengemudi, a person who is an expert in knowing the apa kata, dermaga tu, sama ada di mana cetek, di mana pasang surut, dekat mana arus ada, things like that. A taxi driver, a a contributor to a newspaper where all employed under contract for service, right? And then kalau kita tengok yang tadi professional, when it comes to apa kata professional doctors, yeah, it has to be identified whether it is an integral part of that organization or not. Once you determine that, okay, then good lah. So here the plaintiff is actually the sawyer or at the defendant's sawmill. What happened was dia suffer injury, and then he is no longer accepted as the employee, right? So he wanted to claim, but the plaintiff the defendant kata plaintiff is no longer is actually not the employee. So actually dia employee of the X, meaning Muhammad Yusof ni dia ada a Chinese apa kata agent, that is the Chinese agent yang cari Mak Yusof ni, and then Mak Yusof is to work with Syarikat Jaya Seberang Takik. So now to determine that particular situation, they look at the number of logs to be solved. Work particular person to do the job. Obviously, the employer do not able to control his method of work, right? Berapa dia nak potong, dekat mana dia nak potong, and things like that. Dia kata hari ni dia bagi kuota 300. Bila dia nak potong, macam mana dia nak potong, that is determined by the particular person, the defendant itself. So here the court says actually tugas dia sebagai orang yang memotong kayu tu is the integral part of the business of Syarikat Jaya Seberang Takik. Syarikat Jaya Seberang Takik, you buat business apa? You buat business potong kayu. So this particular person buat apa? Mak Yusof ni potong kayu. Okay. Kalau dia potong kayu, then he is actually an integral part. Therefore, there is a relationship. So, boleh nampak? Now we have alone, or sometimes you use integration in integral organizational test ni pun kadang-kadang juga ada not clear. So they utilize, they meaning the courts utilize multiple tests. We have ready mix, concrete, and Minister of Pension and National Insurance. So what happened in this particular case is that he was engaged to supply apa orang kata macam Grab punya situation lah, right? So he is to supply his own vehicles, and tapi logo to the vehicle is dia letak ready mix Dia tahu lah kan yang apa kata simen yang nampak yang bulat yang pusing-pusing kan, because that is the situation, and this apa kata Minister of Pension wants to summon ready mix kan. Dia kata you tak bayar certain remuneration in terms of apa kata tax on your staff. So dia kata no, ready mix kata he is not our staff. So in that situation, the issue about whether the defendant atau bukan the defendant, whether that particular employee is the staff or not is to be determined by virtue of the test. So first, tengok the employee servant agrees that he would use his own expertise, and then tengok pula on top of that siapa yang bound by the instruction, whether the person is bound by the instruction of the employer or not. So third condition is that the condition of agreement, kita tengok whether consistent with the nature of the job, which is a contract of service. So in this particular three tests above is being used and being identified, and the court says that the the three factors was fulfilled, yeah, and they are responsible lah. If I'm not mistaken, can we check ready mix? I can't remember dia punya outcome, mana dia punya decision. But the thing is that they have to determine whether the relationship is there or not. In Malaysia, it's slightly different. Yeah, we are going to use more towards control test. Tapi from time to time you see cases that applies integral test juga, and then we will see more towards a mixed test being applied. Yeah, soalan. Any questions?
Tak ada kot.
Clear, sir.
Okay, ya. Okay, grey areas, hospital staff macam tu lah. Macam saya kata tadi lah, it might be in the position that control test ni it would utilize the the integral part lah.
Satu soalan, sorry.
Yeah.
Yang contract of service dengan contract for service. So kalau contract of service kira ada special relationship. Kalau contract for service tak ada special relationship. Betul ke?
Dia tak by default lah. By default yang ni memang ada. Kalau contract of service by default, by utilizing this test, you akan nampak dia you akan dapat jawapan kepada that thing lah. Meaning macam mana nak ni
Maknanya satu fulfill, satu tak fulfill. If it's off, it's fulfilling the special relationship. If it's for, it's not fulfilling.
Maksud you macam mana?
Maksudnya special relationship ni kalau off service bermakna dia fulfill the requirement of special relationship. Kalau for service maknanya dia tak fulfill of that special relationship. So there is, kita tak boleh nak kata kita boleh claim dia. So satu tu okay, satu tu is not okay, right?
Tak juga. Contract for service ni pun ada that relationship in terms of liability. Cumanya contract of service ni memang sure. Meaning you have a good a good argument to say that that employee is going to be responsible, the employer is going to be responsible for the employee. Can be vicariously liable. The employer of the contractor is going to be vicariously liable. Ada yang kita akan tengok saat lagi. Tapi for the time being, I just want to introduce this thing sebelum kita masuk.
So this one is contract for services ni, dia in default create special relationship, but then kita kena apply these three tests lah. Kalau contract for services ni, kita nampak yang macam contoh saya kata lah, as a part-time lecturer tu kan, part-time lecturer is contract for services kan. So kalau kita tengok jugalah dia punya berat dia kepada institution tu, ada institution contoh UiTM ni adalah memang core dia memang mengajar, so dia fits into the integral test therefore boleh mengatakan ada special relationship lah macam tu.
Itu kalau off service rasanya yang sefaham saya For kalau contract of service,
Ya, macam mana
dia integral.
Putus.
Putus-putus je.
Okey. Boleh dengar?
Okey.
Boleh.
Right. So, jadi contract of service, bila you pakai test ni, you akan boleh determine the contract of service ataupun contract for service. So, control test, integral test or mixed test, tak kira mana-mana you pakai, boleh determine COS. Okay. Kalau disebabkan this test, dia akan determine COS. Nampak tak saya bawa petak tu dekat dengan this round thing. So, dia akan reject in terms of contract for service. So, kalau contract for service, by default, the employer is not going to be responsible. Macam makcik tadi lah, cleaner tadi kan. So obviously ITM would not be able to be responsible because control test pun dia dah tak fulfill makcik tu, right? So not going to win, right? So make sure that you are going to sue the employer, the re-employer of the makcik. Dalam re-employer pula you kena pakai control test sekali lagi. Di mana dekat situ you akan determine sama ada siapa yang employ makcik tu, siapa yang select makcik tu, siapa yang bagi gaji dia, siapa yang kontrol cara dia nak buat kerja dia. Dia berapa banyak sabun nak bubur, dekat mana nak basuh, dia mesti ada supervisor dia. And then siapa yang terminate. If that company is fulfill empat-empat, then obviously that company is responsible for the makcik lah, not ITM, because ITM fail. You are going to fail the test lah kalau you pakai towards ITM.
Kan ada dekat integral test yang case Stevenson, Jordan and Harrison McDonald tu. Hello? Dengar tak, sir?
Ada kat atas ya?
Rasanya macam lapse lah. Sedengar saya punya information agak lambat sikit selepas saya cakap.
Oh, ya ke?
Okay, case tu kan sir, kalau nak ikutkan definition dia, distinction between contract of service dengan contract for service kan. So kalau contract of service, dia ada special relationship, so it's integral part of the employer. Dan kalau contract for service, there is no relationship, it is not integrated but only necessary to the employer. So dalam case Stevenson ni, kalau ikut organisation test, maknanya of service dia ada special relationship. Kalau for there is no special relationship. So adakah pemahaman saya tu correct or is it no? Kalau ikut integral test, integration test.
Betul. Whatever case yang you pakai, as long dia waktu dia datang tu, obviously the employer akan kata dia independent contractor. Tetapi you kata no, dia bukan independent contractor, dia adalah staff you. So bila argument tu berlaku, dia akan pergi ke court and court akan pakai the test. Okay, and either one of the test is going to be used and dia akan dapat jawapan. Jawapan dia ialah walaupun you kata dia adalah independent contractor, court akan kata dia adalah orang kata contract of service, dia adalah employee you. Walaupun pada namanya contract for service.
Okay.
Yang contract for service, contract for service yang kena terajang keluar yang tak fulfill the test, it's possible. Allah, tak tahu macam mana nak buat.
Tak apa, saya teruskan. Memang putus-putus lagi tadi, susah sikit tapi tak apa.
Tak saya bergerak Kalau sini dengar? Ini dengar?
Dengar, saya dengar. Tapi itulah putus tak putus kadang dia ada tiba waktunya tengok angin.
Ni macam ni? Okay.
So continue dulu. So far okay lah.
So far okay.
So far okay. Macam ni okay.
Dia ada jelas jauh sikit.
Aduh.
Tapi tak apa sir. Dia boleh dengar.
Boleh dengar
Boleh dengar.
I think I close this one sebentar. Okay, nak close. Right. Apa lagi? So balik kepada tadi, obviously one of the issues yang mengatakan sama ada they are going to be responsible or not, it is based on the staff lah. Macam mana sama ada, I think ada problem because my wife tengah nak pakai juga. So there might be conflicting punya ni kot. Ada breaking lagi ya. Hopefully kalau tak clear nanti, this one is being recorded. Hopefully you are able to go through again lah, insyaAllah. So jadi bila masuk kepada hospital staff and things like that, that is an issue yang tadi saya cakap lah, berkenaan dengan whether the integral punya situation. Soalan? So kalau landing a worker, kalau kadang-kadang kita ada satu situation di mana pekerja tu adalah pekerja mahir, right? So macam kita tengok building construction kan, untuk kita tengok bangunan tinggi, pencakar langit tu, dia ada dia punya apa orang panggil dia? Yang atas tu, yang angkat barang-barang. Apa yang panggil tu? Perasan tak?
Tower crane.
The crane tu kan? The crane tu. So if that particular person is not a person yang biasa-biasa orang kan, so the company is specialized in terms of giving that kind of service. So bila kita employ that kind of people, ataupun landing a worker that works under your premise, tapi dia punya gaji dapat daripada dia punya apa orang kata, dia punya employer lah. Tapi at the same time dia dikontrol oleh you. So for example you are the owner of the land atau nak buat building. So siapa kalau dia buat silap, dia angkat barang dan jatuh ke kepala orang, mati. So macam mana? So kita tengok ialah siapa have this particular control, and in this situation tengoklah combination. Okay. Kalau di situation, kalau kita tengok Mercy Dogs, what happened was B worked as the crane driver for A and hired out for crane together to C. So what happened was the agreement kata that A and C stipulated that B will be working for C, but A is to continue paying B's wages. Nampak siapa yang bayar? Yang bayar ialah actually the main person yang employ tadi that particular person A, right? Sorry, B. Here B work. So in this situation, B was negligent in the course of his job, and obviously X was injured. So X wanted to take action. Who had control over the cargo? Yeah, and in this situation, the cargo was to be moved, but he had no control over the method in which B handled the crane. Obviously, cara untuk orang the crane person to move dekat mana dia nak angkat, bila dia nak pusing, things like that. That is being handled by that particular crane driver to himself. So obviously the House of Lords said that A was his permanent employer and therefore vicariously liable. So maksudnya di sini it has to be in a way that you are to utilize the test to the extent that you can prove 100% that the person is going to be ada relationship or not. Boleh kan?
Boleh sir. Bermakna tak kira lah dia pinjamkan kepada sesiapa, as long as dia punya salary is paid by that person, so that person who's paying his salary is the one who's liable.
Dia yang tu satu macam kita secondment kan. Kita ada secondment pada department lain, sama ada whose department is going to be responsible kalau that particular person is negligent. So it depends on the power of control. So power of control in terms of salary, siapa yang bayar, gaji dia by the end of the month, siapa yang masuk account, siapa yang boleh terminate dia. So the balance of probability is more towards the A, katalah A, the one that bayar gaji, the one that can terminate, but A ni dah bagi dia peluang untuk bekerja dengan B. So B is able to control the method, tapi A yang masih bayar. So obviously the court akan kata the X, the question of the person, the defendant is going to be responsible under A rather than B. Boleh guys?
Boleh sir.
Boleh sir.
Okay, but actually I wanted to look at the third one kan, yang the third one tadi tu, under the cost of employment, by virtue of us doing some activities lah kalau boleh actually sebenarnya saya ni tak apa sihat sikit, sekarang tu dah pening-pening lalai. Can we do this? Kita ada 20 orang, can we divide, sini ada 10 rasanya, ada 10 area, pecah 2 orang, each two person akan buat satu case, yang di mana you are to look at that particular case yang I dah highlight kat sini, right? I will share the PDF ataupun the PowerPoint ni. So in order for you to be able to access, then you all buat lah. Boleh kita pecah kepada 2 orang. So I dah bagi dah each area in order for you to explain. Now the explanation I nak minta you all buat dalam pictorial punya form, bukannya in terms of in terms of words. I don't need words, because to make things clear for your fellow friends, I want you to do like macam borang lidi ke, things like that, in order for you to be able to explain in a simple form lah, insyaAllah. Boleh tak kita buat macam tu?
Nak kena lukis rasa
kalau nak lukis, kat sini pun boleh. Kalau you nak buat PowerPoint presentation sat lagi on a piece of paper yang di mana you boleh explain, then okay lah, tak ada masalah lah. You don't have to be like, memang susah sikit nak tulis, nak macam saya buat selalu kan, nak buat benda-benda ni memang susah sikit dekat sini. So you can always do on a piece of paper and then you snap and then put it in, ataupun you take over waktu presentation sat lagi, bila each one of you akan explain lah case tu macam mana. Boleh?
Boleh sir, tapi sekarang ni nak kena choose siapa ambil apa ni sir. Jadinya kalau macam itu nak kena discuss.
Siapa yang nak ambil siapa dengan siapa?
Tak ada, bukan maksud saya case Lisa tadi tu kan. So because every two person will be assigned one. So in order not to overlap with each other, kita kena pick up. So that's how to choose is difficult.
Okay, kita buat sekarang kat sini.
Boleh.
Carelessness yang ni siapa nak? 2 orang.
Tapi nak kena determine 2 orang ni. Okey, tak apalah. Siapa nak dia cakap je lah 2 orang tu.
Maksudnya A ni, can we determine somebody? Siapa nak? Kita ada 22. So, ada yang 3, ada yang 2 lah.
Okey lah, tak ada siapa, saya ambil je lah. Siapa
boleh baca dulu semua, senang sebut dulu semua soalan.
Dia sama je. Every area dah ada, saya dah buat semalam, tengok area. Sama je. Satu kes. I suggest kalau dalam WhatsApp you boleh identify
this question.
Dalam WhatsApp tu you boleh buat discussion, kata A sampai F.
Tapi masalahnya kita tak nampak apa dekat just maybe kita just ambil yang pertama siapa, yang kedua apa, and then kita akan refer balik kat PowerPoint ni. Boleh ke?
Kejap I nak share.
Ataupun share dekat WhatsApp this PowerPoint.
Tak, I nak share dekat
nak buat kat Google tu kan.
Google Slide. I establish it.
Meanwhile, kita orang boleh determine kat WhatsApp tak 2 orang tu lagi senang kot.
You all determine dulu, tapi can you do that?
Okay.
Saya upload benda ni. Okey, boleh tak?
Boleh sir, boleh sir.
Kita try sir.
Kalau kita orang dah buat group, so saya
Macam mana? Macam mana, Jamie?
dekat WhatsApp tu kita orang pilih dua orang, so then kita tinggal tengok dekat case tu and then kita ambil cases based on that lah.
Okey. So, dalam half an hour boleh? The rest tengah buat ke?
Tengah baru nak buka link. Slow sikit.
Slow sikit tak apa.
Internet hari ni slow.
Macam saya pun putus-putus ya.
Kita buat terus kat slide tu sir.
Buat terus kat slide tu kalau inconvenient then
recently macam mana kecil sangat
you boleh
apa macam mana nak bersoal.
boleh you move that thing lah.
Buat terus kat slide ni sir.
Buat kat slide tu terus.
Book dekat chat room ni ke?
Ya dekat ni, dekat dalam tu you just type in lah because you dah boleh control kan.
Okay, clear.
So boleh terangkan balik tak instruction untuk kita orang buat dalam slide ni?
Dia sebenarnya benda ni I nak kalau boleh dalam pictorial punya form lah, dalam orang kata bercerita lah, bukannya dalam bentuk wording, bukannya you cut and paste dia punya apa orang kata cerita tu. I just want in a form of simple pictorial meaning you boleh letak gambar orang ke, you know, then explain macam bercerita.
Berapa lama masa Zah?
Setengah jam.
Okay.
B tak ada. Sebab 22 orang, kita ada berapa sekarang? 23 kan? Yang J ni tak ada ke? Dengan B. Tak nampak ada somebody yang kat situ. Siapa yang baru masuk, tolong masuk dalam grup mana-mana ya.
Tu saya terkeluar ni.
Okay.
Ayo. Hello. Hey, go. Syafiq ni.
Suhaimi, tengah bercakap dengan siapa tu?
Cakap dengan anak dia tu.
Suhaimi tak perasan. Hello Suhaimi, siapa nak tahu masuk?
You all hear me now?
Boleh lah, dengar lah. Sebab tadi saya tak dengar anak you. Bukan main happy ni. Anak ke kucing ke tak tahu lah kan.
Pasal anak tu.
Saya ada belah anjing dia.
Okay, saya mute.
So yang ni pakai gambar sahaja ke boleh letak teks juga?
Pakai gambar je kalau boleh. Sebab kita nak you to explain.
So explain maksud yang explain verbally lah.
Kalau you tengok kan group ramai yang dah mula start letak gambar kan. You can see other groups juga. Yang kalau kita tengok yang Sentry Insurance tu group A tu kan. Sebab you are talking about explosion, then gambar explosion tu kalau boleh you find gambar
Memang sedang mencari je, pandai je, macam baca je fikiran kita nak cari gambar gas station meletup.
Tak payah buat ambil gambar petrol station, lepas tu buat api superimpose.
Alamak, lambat je.
Group 10, template 10 tu silap lah. Ada lain. Sorry. Template 10 yang ni. Sorry ya guys, siapa yang group tu? Allahu Akbar. Yang template ni. Ini silap, sorry J tak ada siapa-siapa. Ada C, slide nombor 4 tak ada orang. Slide 1 pun dah hilang. Mana A ni tadi? Oh, A dah pergi ke bawah. Delete lah ni. C tak ada orang. Dengan J. Tolong bahagi-bahagi tak? Ada 4 satu grup. Jamie, grup you 4 orang.
Maksudnya grup saya 4 orang, 2 orang je kot, sir.
2 orang? I nampak 4 orang. Sorry. Oh, 2 orang. Nampak ni macam 4 orang. Tengok gambar. Ada anonymous sheep, octopus. One ada dengan group you. Anonymous Wolverine dengan you siapa? Crow.
Itu semua bukan sebab sharing itu semua sebab sharing the slide kan?
Bukan. Dia individual person yang ada dekat dalam tu. Say for example, kalau you nampak sekarang,
sebab everyone is sharing the same slide kan, sir?
Kalau you tengok, So kalau you nampak, you boleh nampak kan? So dia nampak 4 orang, nampak kat sini. Sini kosong. Nampak I kosong. Morris tu tak ada. Last Campton tu ada lah. So Morris tu, anyone doing Morris? I, like number 9. Siapa yang baru masuk? Tolong pergi ke slide 9.
Who's ring on number 3, nombor 3 tu?
Number 3 nampak 2 orang kat sini.
Ada orang.
One dengan Hippo. Siapa Hippo?
Number 3 ke?
You nampak
Yes.
you dengan Hippo. Siapa ya?
Yes,
Hippo?
confirm.
Makan ubat sekejap. Dah.
Is that okay, sir? Question number 3.
Okay. Right. Wow. Alright. Ganas tu. Siapa yang perlu bantuan, minta bantuan daripada kawan-kawan. Nampak macam ada seorang takut juga.
Macam mana nak masukkan gambar ni, bila masukkan dia hilang terus slide tu. Macam mana you buat?
Tolong bantu.
Insert image, is it?
Insert image dekat atas tu, lepas tu load daripada komputer ke apa ke, and then letak kat situ. Nanti dia akan dekat atas tu kan ada kan?
Mesti gambar dulu lah ya.
Dekat kita punya, dekat slide kita tu, lepas tu kita insert dekat atas tu apa-apa image ke from computer, and then
Guys, ada putus-putus lagi tak?
Tak ada pun, clear sir.
Ya. Dah lebih kurang 10 minit lagi dah. While doing this, anyone who wants to ask any questions pun boleh, tak ada masalah. Siapa-siapa nak tanya apa-apa?
Tak sempat nak tanya saya sebab tengah kecoh nak buat kerja.
For those yang dah habis, can you put in your name, the group member kat dalam tu, somewhere small, kat mana-mana. Okay, dah siap?
Sekejap, sir.
Saya nak 2 minit.
Okay. 2 minit lagi. Allah.
Okay sir, siap.
Sekejap
Okay, boleh lah. Quite a simple one lah, straightforward.
Straightforward kan?
This one's straightforward.
But I was thinking to cover the whole area, which is under the third one, and the third element, which is the within the cost of employment. I think it is better for each group to be able to go through each division or each each partition of the discussion. Kita everyone would benefit lah kot, insyaAllah. Takut nanti tenggelam, tak nampak apa orang kata, what is the bird's eye view. Kalau kita dah this area is going to be daripada A sampai J. Ada grup lebih daripada satu, lebih daripada dua, lebih daripada tiga tak nak. Apa best presenter, apa grab apa voucher RM10 seorang.
Lah, sir nak kena present lah. Simple je ni.
Tak apa, present apa, but the best saya bagi RM10 voucher lah. per group maksudnya kalau ada 3 orang RM30 lah.
Nak makan sir, tak nak duit.
Kita setuju makan.
Okay, additional 1 mark lah. 1 mark boleh?
10 lah kalau RM10.
Okay. RM10 is equivalent to 1 mark.
5 pun tak apa sir.
5. Tapi boleh dibincangkan tu nanti later. Tapi but not more, obviously not more than boleh, 2 boleh.
Boleh.
Alright. Tadi siapa yang tak 2 minit dah habis lah?
Boleh je.
Alright. So, shall we start dengan the first one? Jamie ya. Saya pindah naik atas balik boleh? Alright. So, we have group A.
Alright. Mukris, start lah Mukris. I think he can explain better, but I carry on the conclusion nanti.
2 minit
2 minit.
No, bukan 2 minit. Mukris. 2 minit presentation sir. Alright. Mukris nak explain or do you want me to explain or how? Mukris?
Okay, saya just
sorry. Before you start, guys, kita dekat sini for those yang mungkin tanya kat mana kita ada ni. See, we are on the third element. It must be within the cost of employment. Tetapi cost of employment might be detailed out in daripada A sampai J, right? So that is what we are doing here right now. So to determine dalam keadaan-keadaan tertentu macam mana, right? So okay, proceed.
Okay, KJB, maybe I can just explain the fact of the case. Nanti maybe you can go into detail on the test to show there's a special relationship. Okay, all right. So, okay, class. So, the case goes by is that the defendant's lorry driver, when he is driving with an oil tanker, he stopped by a petrol station where he negligently and in an unauthorized manner go and smoke at the petrol station. So when he lit up a cigarette and throw the burning match on the floor, it turns out that the petrol station blown into fire. So the court held that the Lorry Drivers Act, the court held that the employer is liable for the Lorry Driver Negligence Act due to it was done during the course of his employment.
So I think I can continue with that. That is fact of the case about the case, the incident. Okay, the vital point actually, okay, for vicarious liability to be established is that first we need a wrongful act. Okay, in this, in order for us to show the wrongful act and then there's a negligence, we can see the damage. So the damage, if we recall back on the semester 1, that the damage is the explosion that is on the gas station happened that time, that thing. And then the second one, we have to look at the special relationship. The relationship, definitely we can carry out a test of, I think in Malaysia, we mostly are using the control test. It's more favorable to the court. So control test, we have to have who select the employees and then who is paying his salary, and who determine his method of working, as well as the one who has the power of terminate. So this control method is always focused on the power who is able to control the employee. So all these are fulfilled because the truck driver definitely is employed by the employer. I mean, is selected by the employer, and the salary is paid by the employer, in this case the salary. And then the method as well, that is he's a driver, and also the employer has the power to terminate him. Okay, and then the third one, we have to look at the that the tort must occur during the employment. So in this case, it's a bit confusing because he's doing the illegal act. So regardless whether the act is legal or illegal, still the act was done in the course of duty. So the employer is liable for the conduct of the employee. So the conclusion is that the employee has to pay off all the damage. That's the conclusion. Thank you.
Okay, good. The rest, are you clear? So this A is about the issue within the course of employment, right? So how about carelessness, of the defendant? So in this case, the truck driver, by lighting the cigarette and causing the explosion. So the court says the benefit, you're looking at the benefit of the cost of the action that is being done, which is to deliver gas or petrol, right? So whose benefit? In the course of the duty, obviously, but who is going to benefit? The employer is going to benefit. So whatever the positive or negative thing that is being done by the employee, so therefore the employer is going to be responsible. Boleh nampak guys untuk A?
I think the one that people are confused is that because the act is done negligently and the act was illegal, that may be a confused thing. But even during the course of duty of the employee, regardless the conduct is legal or illegal, it's the duty of the employer. Maybe in court, if the court in court, the employer can defend themselves if we want to defend himself, that they have said, okay, I have told my employee that they shouldn't do this. That one maybe they can defend, but in this case maybe they are not able to defend it, and then they lost in that case.
Definitely, but when it comes to court, the chances of the employer to be responsible is very, very high, because that person, irrespective whether the instruction is given, It can be in a form that macam you pakai apa exclusion clause lah, and saying that I already given the instruction, but the fact that the lorry driver, when you employ that particular person as your lorry driver, you should be able to determine whether that person is a smoker or not. Then which you have failed, right, to determine whether that person is a smoker or not. In this particular situation, you have negligently select a person to represent an activity that is very dangerous. So you cannot avoid liability in saying that, oh, I already done my job, So the court is not.
In case of during the selection of the employee, he already stated that are you smoking or not, and then that guy lied in his statement saying I'm not smoking, but he's a smoker. Still, in that case, the employee is liable.
Yeah, it is still, because in the course of the duty that you have already stated here, in the course of duty, meaning it is not outside. He did not go back from the job and then berhenti dekat that petrol station and smoke. That might be excluding the liability of the employer. But when it comes to this, he is in the midst of doing his duty. So this is macam tak masuk akal, right? But it represents all activities of an employee whenever they were to do their job, right? Say for example, you kena pergi overseas, ataupun you kena pergi outside a branch. Say for example, you're from HQ, you're being asked to go to the branch, and then while heading towards the branch, you met with an accident because you were negligent, right? So the employer is going to be responsible for your negligent act, because you are doing for the benefit of the the employer and within the course of duty itself.
So is there any other way to argue around on the side of the employer? Like what can Jimmy say through if we can prove that through the interview, or maybe from dia punya
because actually the employer, let's say they have done the due diligence on that potential employee.
Let's say if the employer can prove on that,
because the court is more towards the person who is suffering. They favor kepada people who are suffering that damages.
Tapi if it's lit a cigarette, okay, kita nampak. Tapi kalau the act is actually statutorily forbidden, let's say in the course of duty, truck driver ni go and then rape someone throughout, misalnya kat gas station, dekat toilet.
Then that is an excuse to be used by the employer in saying that this is beyond his duty. I told him to go to that particular place. Like I did not, allow him obviously to go and rape people. So that is they call it a frivolous act of the defendant itself.
But then the employer can also say, I asked him to drive, I didn't ask him to smoke.
True, it has been done in that particular case that they argued that they did not allow, and they tried to go behind the fact that they have already given instruction and things like that. Here the court is saying that the benefit that you are getting from that particular person in your employment, so you're going to be responsible for the negative part of that person also.
Okay, saya dapat extra 2 markah. Thank you.
Right. The second group. The second group, we are looking at unauthorized mode of doing something authorized. You are authorized to do something, but you do it in a way that it is unauthorized, or maybe a mistake. So the case of Bailey, Manchester, Sheffield. Okay, can we have the group?
Okay, hi everyone. My name is Adizul, and with me is Amir Zahid, representing the Bailey against Manchester, Sheffield and Lincolnshire Railway & Co. Okay, the fact of the case is regarding the plaintiff was a passenger on the defendant's train. One of the porters of the defendants pulled him out of the carriage due to mistaken belief that the plaintiff was traveling on a wrong train. The plaintiff suffered severe injuries. So the porters was kind of like of a bonzer on the train. So maybe because wrongfully identification that the porters has pulled the plaintiff from the defendant's train. So the issue arises is whether the issue arises is who would be liable on the injuries suffered by the plaintiff.
Okay, I will continue from that. So it was held that the defendant were liable, meaning the owner of the train were liable, because here the owner didn't do anything unlawful, but the master will be liable even if the servant acts on the belief that he is doing something, some lawful act which he is authorized to.
Meaning in simple word macam mana?
Yep.
In simple word meaning
the porter is authorized to pull a passenger from the train. Okay, but he put the passenger, the wrong passenger, meaning the plaintiff was rightfully supposed to be in that train. So
dia macam dia tarik orang tu kan secara kasar kan.
Yeah, and orang tu dah kena severe injuries. But even though the porter boleh tarik, he can pull the passenger if the passenger was travelling on the wrong train. But since the plaintiff has the right to be there, so
the porter was doing the right action on the wrong person.
Yes, and
in short.
Since the action caused severe injuries, therefore dia boleh tarik, tapi dia tarik tak boleh, not to a point that cause severe injuries to the plaintiff.
Tarik orang yang salah, orang yang betul.
Actually dia bukan he is doing something that is authorized lah ya, in a way that dia memang boleh manage the people that wants to aboard the train, right? But not to the extent to tarik to causing injury to people.
Yes, sir.
Which itu yang silap tu kan?
Bonzer. Yes, sir.
Alright.
Yes, sir.
Any questions from the whole group? Macam mana? Are you can you understand the situation? Do you have any questions?
Yes, so just nak notify here ada Nur Hashikin, but dia tiba-tiba ada klien datang rumah dia sekarang.
Okay. Maksudnya? She is going out from the class.
Ada klien datang rumah dia sekarang, so dia
it's okay.
She cannot join.
Alright. Okay. Thank you, group 2.
Very good. Thank you, sir.
Group C. So here we are looking at tort committed in protection of the employer's property. You know, dia jadi macam tadi lah, bouncer sikit, terlampau over nak protect the employer's punya property. So we have a case of Holland and Pa and Son. Right. Yes, can we have C to explain? Wan dengan Nick. Wan, Nick.
Sorry, tak enable mic, cakap seorang je tadi. Sorry.
Tak apa.
Alright, the case involved with an employee of a sugar company who closely following his boss in front of his truck. And then upon seeing a boy with a bag, and then this employee suspect that this boy actually steal from his employer's property, the sugar, and then the employer come and hit that boy, and then the ball fell, and then his employer truck hit the boy's leg and then broke, right? And then the boy is actually pledged is not guilty for the stealing, and then the court decided that the employer itself is liable, impliedly authorized his employees to the in doing the tortious actions. That's the facts. Yeah, that's the question lah. Simply put.
Wow. Okay. So the rest of the group boleh nampak when it comes to the act of the defendant, which is the employee, trying to protect the employer's property. So yeah. So you in the midst of duty juga lah ni, kan? Because we are here looking at the area of within the cost of employment, right? So if it's within the cost of employment, to what extent? Just now we are looking at macam Jamie apa, this is about carelessness, this is about mistake. Yeah, the second one is about mistake, and the third one is about an extension ataupun too committed in your work, you know, but you cause somebody to suffer some kind of damages.
Okay.
Any questions, guys? The rest of the group? Jamie, anyone else? Do you have any questions that you want to ask?
So far, okay.
So far, okay. All right. Good. Thank you, Wan. Next, we have the D, where workers delegating his responsibility. So you're supposed to do your job, but you give some other people job to do. Right.
Assalamualaikum, sir.
Assalamualaikum.
In this case, a lorry driver, he had a strict instruction from his employers not to allow the lorry to be driven by anybody else. But a lorry driver allow a stranger to drive his lorry when an accident occurred due to the negligence of the stranger. The stranger itself had never driven a lorry before, no driving license, and he is also incompetent to move a heavily loaded vehicle in the confined space. So it was said that the employer was liable not for the negligence of the stranger, but for the negligence of the lorry driver for letting a stranger to drive a lorry. So the plaintiff suffered permanent permanent spine injuries, and Su boleh sambung Su.
Yang mana dia memberi efek, dia tak boleh angkat barang-barang berat. Jadi masa tu dah kejadiannya dah 8 tahun yang lalu. Jadi court memberi damages kepada plaintiff dengan mengambil kira bahawa the fact that plaintiff lost all the damages awarded contain a substantial though concealed element of loss of earning between the date of the accident and the date of the trial 8 years later. Semasa kejadian tu 8 tahun yang lalu, maksudnya kalau nak kiranya kalau nak kira pada waktu sekarang pun dia ada posibiliti bahawa dia pun mungkin ada kehilangan kerja ataupun salary.
Siapa yang plaintiffnya? Is it the lorry driver yang yang bagi orang lain bawa ataupun somebody else yang is it siapa?
Somebody else.
Lorry driver A dia bagi dekat B yang siapa yang accident tu? Is it
someone else yang
yang kena langgar lah. Okay,
yes,
good. Everyone else, are you okay with the explanation? Do you have any questions that you want to ask? So you cannot delegate your responsibility that is given by your employer, and by delegating, then the employer itself is going to be responsible for the act of delegation. Nampak to the extent the court is able to extend.
Yes, sir. The employer was negligent in employing a careless servant, sir.
So servant who doesn't obey the instruction of the employer.
Sir,
Ada case, Jamie.
last semester punya, I thought I saw one question given by the lecturer lah kan. There was a case where the driver of the bus, and then maybe because of he was sick and he cannot drive, so he asked the other person, the conductor who is not supposed to be a driver, tapi dia drove because of his condition of not able to drive anymore. Is it okay in terms of when it comes to emergency cases that you have to do what you have to do? Then is that okay, or is still liable that because the bus masih dia drive to and then caught macam slight accident and everything?
Is he authorized to give someone else to drive or not?
No, he's not. But he had to because he was sick. Because he was there while driving, he was sick. So if he continued driving, it's more damage than letting somebody else's driver.
Then he should stop lah. He should stop.
Okay.
By giving to someone, then obviously it reflects this particular case. When you are not supposed to give to someone else the act of driving, you have given it, so the employer is going to be vicariously liable.
Regardless if he's actually in the condition of not being able to.
Yeah, irrespective of that. However, if you go to the material, reading the materials later on, you will see cases of similar like this, where this particular driver took someone up, and allow someone to be inside the vehicle, right? And the court have two method of approach towards this, which is one, that the employer is going to be responsible, but the employer is not going to be responsible if the employer has indicate in terms of some indication in terms of written statement on the vehicle itself that nobody is to be on the vehicles. So kalau lah dia kata a waiver that is given, dia dah bagi verbal warning to the driver not to have someone, katalah dia driver tu bawa bini dia, right, together in that particular trip. So obviously the employer has already given a verbal instruction not to do so. And then on top of that, there is a label that is stated within the vehicle itself that nobody that is not authorized can be within the vehicle itself. So obviously then the employer can say, I have given him instruction, I have already stated clearly. So in that particular case, the employer is not going to be responsible. So what you have to do is, if you are the employer, then you have to be very detailed in terms of doing things. So macam identifying that yang meletup tadi Jamie punya situation, then steps has been taken lah.
Cuba kalau saya tampal stiker, no stiker kat lorry driver tu kan, kira macam dah taken extra precaution step.
So it's thought is about balance of probability, right? So as long as you are able to prove that the person is doing something that is outside the purview of your control, then you can say that I cannot control him. Yes, he was doing the thing for my benefit, but he has done something that is beyond my control. So he is no longer giving me the benefit, but taking things on its own. So macam ni juga lah yang this particular situation, then the employer is going to be responsible.
So satu soalan.
Yes.
dalam keadaan macam Kak Juni cakap tadi, emergency, memang tak boleh, tak dia terpaksa delegate kerja dia pada somebody, tapi dalam kes ini dia tak pandai drive the lori, tapi dalam contoh saya nak begini, dia pandai drive the lori. Cuma masalah dia bukan kepada dia incompetent dia untuk dia drive the lori, tapi untuk ada masalah pada lori tersebut. Kalau macam tu, is it still the employer tu, dia still liable juga ke sir?
Dia by default lah, kalau kita tengok ni by default if it's within the cost of employment, right, so and on top of that the benefit is going to be received by the employer in terms of his employment punya waktu dia tengah buat kerja, who is going to benefit, then the benefit is the employer. Definitely by default the employer is going to be responsible. Cumanya dia nak lari. Bila nak lari, then you have to do proving in court that you have done all the steps needed in order for that particular situation from happening. Macam yang tadi tu, he is supposed to stop, and what he has to do is to contact the employer to get permission whether the employer is allowing him to give the vehicle to somebody else. Boleh kan?
Okay sir.
Alright. Can we have another group? Group E. Here we are looking at workers acting on its own benefit. Yang ni nampak kita nampak lain sikit lah, di mana we are looking at the benefit of that particular person doing for his own. Yeah. Can we have the case of Zakaria?
Okay sir. My name is Fatin Shazrin, and this is my group 5. Ada Nur Hasnita and Siti Adila. So this case is Zakaria bin Cik So and Choi Kung Long and another. In this case, the plaintiff, which is Zakaria bin Cik So, he is a driver at Research Institute in Ipoh. After sending the director, which is the boss, the director home, he drove home for lunch, and an accident occurred on his way home, and it is within working hours. And the court held that the state government of Perak is liable since Mr. Zakaria is the employer is state government of Perak. The court held that even though the purpose of the trip, which is the fact that he drove home for lunch, even though it did not have anything to do with his employer, but it was something expected to be done in the course of his employment, and the accident is occurred in the course of his employment. So the employer is vicariously liable.
Okay, good. Any questions, guys? Nampak Say for example, if you're employed and then to do something, to travel from point A to point B, which is like 50 kilometers away, it is expected of you to stop or to break the journey. Kata dah 50, mungkin sikit lah. We are talking about 150 kilometers. Obviously, you have to stop. You are not supposed to continue driving. It might be in a way that is going to be detrimental to your health. So you break in order for you to take a drink. So while changing your route from A to B, you move yourself from A to C, and in order for you to go to B. So the fact that you went off your track, it is expected in this particular case, the state of government of Perak is going to be liable for the act, which they say that he has done for something for his own benefit, meaning takkanlah orang tak makan, doing something. So mana-mana kerja pun, kita pergi kerja mesti ada time makan, right? So if a person that is going outside the scope of the time of working, then obviously that person has to stop untuk nak solat, untuk nak makan. That is expected. Yeah, the key word here is it is expected thing that the worker is going to do. So you are going to be responsible for that.
Sir, nak
Question?
tanya soalan.
Yes. Yes.
Kalau kes tu tadi terjadi di bulan puasa dan dia Muslim, boleh tak?
Boleh? Bulan puasa. Dia Muslim.
Boleh tak?
I don't know because
Dalam hal ni lunch is a necessity, kira part of his duty.
yeah.
Tapi bulan puasa you are not supposed to eat and you are a guy, you cannot have any other excuses. So
dia tak sihat kan dia? Dia tak sihat time tu.
Alah, tak ada, kalau dia tak boleh nak proofkan apa-apa, memang dia balik nak makan. So it's
I think kalau you rasa you buat macam mana? If you're the judge.
I rasa I kata employersnya liable sebab kenapa kau boleh make sure kan tak boleh ensure kau punya employee itu puasa. Macam tu. Ataupun tapi
puasa is a personal thing.
Okay, public and private things ke, tapi benda ni terjadi ketika dia in the course of duty, so it's still under the confine of the under the power of the employers to control.
Betul. We are not looking about the act of dia makan, but within the course of the employment. So within the course of the employment, so who is going to benefit from him to move from one place to another? The employer kan. So irrespective whether what he has done is in religiously is wrong, but still somebody suffered. You know, that person who suffered can be able to get the compensation from the employer lah.
Sebab kalau nak ikutkan reasoning dalam kes ni is because dia perlu makan and it's part of the duty, keperluan dia. But then bulan puasa you are forbidden to eat as a Muslim, but then kalau ikutkan reasoning dia kat dalam kes ni seolah-olah macam employers tu tak liable sebab tak ada benefit for that employers. I don't know.
I think he can the way I see it, if I'm the judge, I would say that any person in that particular process have to stop, you know, to have a break, irrespective whether the break comprises of going to the toilet ke, you know, take a break, lingering around ke, you know, or makan. That is not the issue. The issue is within that particular process, mesti berhenti je. You know, anticipation must be there lah. Okay.
Okay, sir.
Alright. Alright, can we have F, which is acting against the employer express provision. Now, the employee is, macam Jamie kata tadi kan, this is what happened in my situation dekat kilang pun, kita dah bagi instruction, kita, you know, punish that person, still benda tu jalan juga. Okay, we have the case of Harrison, please.
Good morning, sir, and to my fellow friends. Okay, in Harrison v. Michelin Tire Co. Limited, Harrison, a tool grinder employed by the defendants, was injured in the course of his employment while standing on the dartboard. While standing on the dartboard, he's actually talking to a fellow employee. The injury occurred when another employee indulged in some horseplay and caused H to fall. So Harrison sued his employers for compensation for his injury, claiming they were vicariously liable for X action.
Horseplay tu apa?
Macam gurau, joke.
Dia main-main lah So when it comes to forklift biasalah seronok sebab dia kecil, dia boleh main pusing-pusing. Aduh, I still remember clearly my staff pening kepala. That is what they are racing. Forklift, you know. Aduh. So this is what acting against the employer's express provision. So here the court says that the defendant will held liable. Kan? That this is the situation because you are unable to control. But looking at it, it is for the benefit within the course of the employment.
Sir, nak tanya sir, kalau court kata employer dia liable, lepas tu kan employer dia out of court case ke, employer dia pun tolak gaji orang yang buat tu. Is it lawful things to do or not?
Yes, kalau employer boleh, tapi from the employee untuk nak minta reimbursement tak boleh. Dia ada SOCSO dengan EPF punya law that can come in to say that you are limited in terms of the compensation yang you nak minta balik daripada reimbursement.
Okay.
So when it comes to liability of the employer, dia boleh lari, and then kalau lah kata dia kena bayar sebab compensation tu dia kena absorb, dia boleh punish that staff by virtue of asking the staff to bayar balik untuk damages tu, installment ke, potong gaji ke, things like that.
Okay.
Alright. Group 7.
Hello.
Before here we are looking at kalau employee tu dia at the frolic of his own, meaning he is going beyond his particular act that is authorized by the employer. Macam mana? Kalau dia gila sikit, dia jadi angin. So we have a case of couple by AB dengan Nora Bani.
Yes, AB here. Right, good morning everyone. Okay,
morning.
This case is actually happened in a bus, which there's a bus conductor here in this picture here, and there's one elder lady, and also there's another passenger. Okay, so this bus conductor that did not treat this old elder lady well, and this passenger that feel not comfortable with it, so they start to have some sort of like argument. Okay, and then it's just merely an argument, but after the elder woman got off from the bus, they start to have much more vigorous argument and then end up with a fight. So the bus conductor throw the ticket machine to the passenger. So the passenger had a severe injury on his head, and after that the passenger got blind. So the Court of Appeal said that the bus company is liable to the act of this bus conductor. But after that, in the privy council, the bus company, they decided that the bus company is not liable. This is due to, the elder woman had already got off from the bus, which means that all the behavior of the bus conductors actually not in the course of employment, which means everything of the act of the bus conductor is merely an emotion, act of its own, that in the result of getting into a fight with this passenger.
Okay, so guys, nampak? So the subject matter is no longer there, where we are talking about the woman being ill-treated by the bus conductor. So in this situation, the bus conductor took the matters further after she had left the bus and attacked that particular complainant. So what happened was he got blind, right?
Yep, he got blind.
Okay, so in that particular case, the court says that it is beyond the authorized thing that is being allowed for the bus conductor to conduct, which is to do whatever his job lah. But after that, going beyond that, taking things into his own hands, then obviously he has every right to be responsible for that. But here, the court says that the bus company is not liable. Boleh faham, guys? going beyond your
Tapi
apa?
bukan still in the course of his employment ke pada masa itu?
Yes. This kita nak ambil example yang sedikit yang di mana court akan kata the employer is not going to be responsible. So this is one of the exception, which is frolic of his own. Maksudnya dia sendiri ambil action. Kita nampak macam the rest is the same kan, but this one is beyond the authority, beyond the things that is reasonable for a person to be doing. You can enter into argument, obviously. You as a bus conductor kan, maybe because of the lady is not giving any proper change ke apa ke, you can be in a position of authority, but you cannot go to the extent to hurt people. Macam mana?
Okay. Alright.
Yeah, frolic of his own, that is the area. So in this particular case, you will see that the bus company or the employer is not going to be responsible. So the next one, we have fraud. Yeah, we're looking at another one is fraud. How about fraud? We have the case of Floyd. Shuaimi?
Okay. Assalamualaikum and a very good morning to everyone. So everyone can hear me clearly, yeah?
Yes, can.
Okay. For the offer of 2 marks as promised, sir. I will briefly explain the facts of the case, judgment held, and the legal principle applied under this case, inshallah. For the case of Lloyd versus Grace Smith and Company, this is an old case in 1912. Mrs. Lloyd delivered the title deeds of her cottages at Ellesmere Port to the solicitor's managing clerk who defrauded her. Mrs. Lloyd delivered the title deeds of her cottages to the solicitors. Thus, the important decision of the House of Lords in Lloyd versus Grace Smith and Company, often being treated as an authority on vicarious liability, is probably better explained in agency. It was held by the House of Lords. Vicarious liability can extend to fraudulent acts or omissions if those were carried out in the course of the employment or within the scope of the apparent authority by an employee or a partner conducting the business of a type which he had a right to conduct. The principal was liable for the fraud of the agent because conveyancing is part of the ordinary business of solicitors. The client had been invited by the firm to deal with their managing clerk. It was irrelevant that the agent acted with a dishonest purpose for his own ends. His act was of the class or kind of acts which fall within the ordinary business of solicitors. So in summary, the clerk employed by firm of solicitors has dishonestly obtained property from client for his own benefit. So the principle applied under this case that there is no requirement that plaintiff or should be aware of A's action, and it does not matter that A acted for their own benefit or not for that of plaintiff. So the fact that servant intending to benefit himself, not employer, does not necessarily mean servant acting outside the scope of his employment. Therefore, master is liable for dishonestly or fraud of his servant if it was done within course of his employment, no matter whether for the benefit of master or benefit of servant.
Okay, good. So coming back to the questions, can you the rest of us nampak what is being highlighted here? Kalau lah kata the employee is committing fraud, so in this particular case, the court says that if it's done within the course of the employment, and the fact that you benefit in terms of assigning a person to handle that particular transaction, and irrespective whether that person is doing fraud or not, you are going to be responsible.
this comes back to the core of business that we were discussing earlier, right, sir?
Yeah, betul. So because who is going to benefit actually by putting that particular person there? Obviously the employer, you know. And secondly, that person went to the office of the solicitor within working hours, or irrespective whether working not within working hours. If it's, say for example, he or she met outside the office to collect the document, right? But that is considered as within the course of employment also. Okay, ada dua benda kan within the course of employment, irrespective whether in office or not. And on top of that, the benefit is going to be received by the employer. So obviously, the argument that I cannot control the staff when that staff fraudulently change the name of that house to himself, no, that argument tak boleh pakai lah. Okay. Any question, guys? Jimmy? One? Anyone else?
This is quite straightforward case, sir.
Yalah. So jadi when it comes to fraud, the benefit, the underlying things that you have to remember here, all the way from A to J, would be it is within the work scope, and then it is authorized, and then the benefit is going to be received by the employer.
So there goes my 2 marks.
Tunggu lagi habis. Right. Okay. We have second last would be the case of Morris. So Yani under scope apa? Dah hilang.
Oh, tak dengar. Sayup dia. Siapa ni suara Razif tu? Maybe kena dekat.
Hello, good morning.
Morning.
Okay, good morning sir and fellow classmates. For this case, Morris versus C.W. Martin and Sons Limited, the facts of the case is that Mr. Morris, the owner of the Ming coat, sent her coat to the dry cleaning shop named Solomon Mark Beder. But then Mr. Beder stated that he did not do the cleaning himself, and it was subcontracted to the defendant firm, C.W. Martins and Sons Limited. They themselves were very well-known, reputable cleaners, and upon collecting the fur coat, the defendant company, while in their position, it was lost. And then Mrs. Morris sued the C.W. Martins and Sons Limited, claiming that they had not exercised reasonable care in maintaining the code. But then the argument was turned down by the first trial judge, who believed that the defendants took reasonable care to safeguard the code. He stated that the acts of the defendant's employee in stealing the code were not committed in the course of his employment, and thus the employer could not be liable for them. So the judgment should be presented by Razi. Razi?
Hello, Jay? Kena kuat sikit. Dekat sikit.
Buka suara sikit, tak dengar.
Tak dengar. Suaranya terlalu sayu.
Tak apa kalau macam tak saya sambung.
Okay.
Okay, and then because of the first trial judge declined the claim, then for the Lord Denning then established the key question whether the liability based on Mrs. Morris that she could sue the cleaning firm for the theft of their employee. And then Mr. Beder could clearly himself said that he could sue the cleaners, but the plaintiff, if the plaintiff have the right to sue for the misappropriation by their servant. And then Lord Denning stated that the duty of care was owned by the sub-baileys to take reasonable care of the fur coat. This duty was non-delegable in that they themselves were personally liable for their employees in stealing the coat. So it held liable between whether it is clear there was no contract between Mrs. Morris and the eventual cleaners, right? However, the relationship of the bailier and bailey of a chattel can exist outside the contract. So the duty of the sublease to take due care of the position of the is held that it was liable for Mrs. Morris to sue the plaintiff, the cleaner.
The defendant,
The defendants, yes.
Okay. So in this case, you can see that the extension ataupun the underlying thing that the court is saying that you owe that duty, you owe that duty to your activity of your staff. So the staff mishandling the what they call it, the materials ataupun the product is going to be your responsibility also. Okay. Boleh nampak? Guys, ada soalan?
Ada, sir.
So the fact that you tak boleh lah, you cannot delegate delegate that duty to somebody else because the responsibility is yours in the first place. So that is the situation lah. Boleh?
Boleh, sir.
Okay. And last one, we are looking at the time, and whether it is relevant in terms of to determine cost of employment. We have siapa to present this, Samson? Ada tak? Siapa yang buat ni?
Saya, sir.
Okay, good.
Okay. This case in ComTerm is is about time and relevance, where the employee rushing to work injured another employee at the place of employment. Therefore, there is where space would come in and would then make the employer vicariously liable. It is established that for an employer to be vicariously liable, their employees must be under cost of employment. So from here we can see location or premises on which the injury occurs, where the performance of the work is less flexible. In that work must be done at the employee's premises. Entry the premises without the employee permission of non-working day is clearly outside the scope of employment. That's all.
Okay. Questions? Now we are looking at this particular case whereby driving too fast in order for you to clock in. This is also what happened during my time dekat Kilang, when we normally ask people to go back when they are late, 5 minutes, even 5 minutes late. So they are not going to get their salary if they are late, because we are looking at the manufacturing punya processes, right? So we cannot condone this type of activities ataupun this type of practices by staff. So pekerja kilang kalau bagi muka, dia orang akan naik kepala lah. So accident happens when people are rushing in, ramai-ramai, dia orang last 5 minutes sebelum siren bunyi, semua nak kalang kelibut, semua nak punch in. There was accident. So in this case, the employer is going to be responsible because the issue here is about within the cost of employment. So going to your office and coming back from the office is considered by the court is within the time and space of the employment. Bahaya kan? You might be responsible for the provided that the thing that is happening is within the vehicles belonging to the company lah. Tapi kalau it happens in front of the apa orang kata premises, then you are going to be responsible also. Boleh nampak guys?
Boleh sir, boleh sir. Dah pukul 11.30 habis waktu.
Okay, for the decision, can you everyone put in the names now? So I can decide siapa yang untuk markah tu.
Untuk markah yang dijanjikan.
Actually, for the effort that everyone took, everyone dapat 2 markah.
Alhamdulillah.
Thank you very much, sir.
Thank you, sir.
Make sure ada yang ni lah, letak betul-betul lah. I mean your names, you know, macam J ni tak ada siapa pun nak letak, you know. You put your names properly, and your metric number. I akan nampak your metric number tu. Nanti I kena cari pula. Alright, so guys, thank you so much. You decide lah bila nak ada additional class. Ada satu area yang tak habis lagi. Then extension of that, apa orang kata, liability of independent contractors pun tak cover lagi. So can we do that after this later? InsyaAllah, you decide malam.
Boleh.
Alright.
InsyaAllah.
Lepas isyak pula, lepas maghrib boleh. Alright, so thank you very much guys. See you next time. Assalamualaikum.
Salam.
Salam.
Thank you. Everyone kena keluar. Falik, Faria, Nurul. Thank you. Assalamualaikum.
Waalaikumsalam. Thank you very much, sir.
Thank you, Chris. Nurul.